The abortion industry likes to claim that they are healthcare providers, even though pregnancy is not a disease cured by abortion, and abortion isn't healthcare. More than 95% of abortions interfere with a healthy pregnancy. Yet at every turn, they fight regulations designed by medical professionals to protect patients in real healthcare settings. Abortion providers should have to follow the same health and safety laws that other doctors follow. This doesn't seem controversial, and yet it's the focus of a Supreme Court case involving June medical services being heard by the Supreme Court this year. My name is Clarke Forsythe, and I'm Senior Counsel at Americans United for Life. Today I want to explain how the abortion industry has escaped important health and safety regulation for years, and why Louisiana is right to regulate abortion facilities the same way they regulate other ambulatory surgical centers. It's important to understand that the Supreme Court has controlled the abortion issue since 1973. That's what Roe v. Wade means. The court controls abortion and decides whether any limits on abortion are legitimate, including any health and safety regulations. In 2014, the state of Louisiana passed a bipartisan common sense law, Act 620, that stated that abortionists have to have admitting privileges at local hospitals. This means that in the case of an emergency, the provider is able to quickly and smoothly transfer the woman and her medical data and communicate with the emergency room doctor and possibly fix mistakes in the hospital. This is the same standard applied to most other ambulatory surgical centers. Doctors call these admitting privileges. Nothing about admitting privileges should be controversial. If you are undergoing other ambulatory surgery, for example, and you suffer complications, you want your surgeon to be able to quickly transfer over your medical records and get you admitted to the emergency room. But some abortion providers cannot get admitting privileges for a variety of reasons. The hospital also is legitimately concerned about the skill and credentials of any doctor who wants to practice there. Hospitals should be able to require that doctors are credentialed and have a record of skill, competence, and safety. Unfortunately, the state of Louisiana has documented many cases of health and safety violations by abortion centers over the years. The abortion lobby argues that asking for an emergency plan in place through admitting privileges will create an undue burden because some abortion providers can't get those privileges. But emergency plans reflect the reality that sometimes something could go wrong, and sometimes it will. The question is whether abortion providers made arrangements to provide continuity of care in an emergency to quickly get an injured woman the help she needs, something doctors are normally required to do. Continuity of care is essential to basic health. These standards may lead to some facilities shutting down, but that's not Louisiana's intent. The state's intent is to protect the health and safety of women. But that doesn't mean these laws unfairly target the abortion industry. It means that the abortion industry has lower standards than regular surgical centers. It's important to require high safety standards. So let's review. First, the state of Louisiana exercised its authority to regulate medicine, an authority that has been recognized for centuries. They said that abortion facilities should be held to the same safety standards as other surgery centers. Second, the abortion industry argues that these regulations put an undue burden on them and restrict a woman's right to an abortion. But all regulations, by their nature, impose requirements to set high standards. In a democratic republic, legislatures should be able to make trade-offs between added costs and safety, like we do when we mandate seatbelts in all cars or require restaurants to regularly sterilize their equipment. Finally, the abortion industry's inability to comply with normal safety and medical guidelines says more about their standards than it does about anything else. This case involving June Medical Services is invaluable to show the Supreme Court and Americans that abortion has its risks and that there are substandard clinics and substandard providers. Women deserve to be treated with dignity. The pro-life movement needs to be on the side of women because abortionists certainly are not. Abortion is bad for both mother and child.